Okay, so thank you very much for the opportunity to present. It's been great to learn more about Zvi. All I can really say is that I wish I'd have met him and got some wisdom from him, but Mark has passed on a number of stories and comments from him, so I've learned through Mark. So this paper is Screening Property Rights for Innovation, as was mentioned, joint with Mark Schankerman. So the basic motivation is that public agencies play a major role in promoting innovation. To give two examples, the federal government finances just over half of R&D expenditures, and the Patent Office, which is the focus of this paper, issues around 400,000 patents every year. And so we know that these play a major role in promoting innovation, and despite this, there's not a huge amount of evidence and definitely no consensus on, first, whether these organizations and these agencies allocate resources efficiently. So we don't really know if all the money that's being given out by, for example, the NIH is being sent to the right sources, and whether patents are going to the right sources as well. So we don't have great evidence on that. And second, and perhaps more importantly, we don't know what would happen if we make changes or reforms to these agencies, how it would affect the performance of the agencies. And so this paper is really part of a broader research program, which is to use structural economic models to study the effectiveness of these kind of public agencies that support innovation, and we hope that this is the first of many that analyze public agencies in various contexts and countries. So in this paper in particular, we focus, as I just mentioned, on the patent screening process in the United States. And as I'm sure many of you know, there's a policy concern that perhaps patent rights could be an impediment rather than an incentive to innovate. And one potential cause that's often given is that it's because there's ineffective screening by the USPTO. The conventional wisdom is, and we hear it a lot, that there's many patents being granted that don't make sufficient inventive step. And actually one of the things that I'm going to talk about throughout this paper is that the far more prevalent error is actually that they don't grant rights to some claims that deserve it. So, but this is what we hear a lot about, the conventional wisdom, and this is the context of this paper. And what we do is we estimate really the first structural model of a patent application process, and we have three key ingredients in the model. So first we have the extrinsic incentives of examiners and applicants. So we have a patent examiner and we have a patent applicant. They have incentives. So for example, the applicant is trying to scope out as much property rights as they can, bearing in mind the fact that if they try and claim too much, then they're going to be rejected by the examiner and have a long and costly negotiation. But the examiner also has incentives, extrinsic incentives from their pay structure, so they get credits for making certain decisions, and that's determined by the Patent Office. So that's the extrinsic incentives, but when we take seriously in this paper the idea that these examiners could be intrinsically motivated as well. So they, in the Besley and Gattek kind of language, they want to align with the mission statement of the Patent Office. And so those are the incentives of the two agents, and we also model the very structure of negotiation itself, which I will detail as we go on. Those are the inputs to the model, and what this delivers is predictions on the effectiveness of screening, by which really we mean type 1 errors, type 1 and type 2 errors, so that's granting patent rights to invalid claims that don't make sufficient inventive step, aren't far enough away from existing art. That's a type 1 error where you grant incorrectly, and a type 2 error is where you don't grant patent rights to something that actually deserved it. And so we can calculate and quantify the extent of these two errors through the model, and also resolution speed, so how fast does this negotiation last. So the model delivers these out of it, and then we can use this model, once we've estimated it, to both quantify the effectiveness of screening and to evaluate reform. So we can change the incentives for examiners and applicants, and we can even change the very structure of negotiation itself. So how many rounds are they allowed? I mean, currently, the examiner and the applicant can keep fighting indefinitely at a cost, and we've considered situations where that's not the case in a counterfactual. Very good. So I'll spend a little bit of time on this slide. This is a timeline of how the model works, and so there's a lot to go through. I'll explain it slowly. So the first step is that the applicant obtains an invention. So exogenously, they have these patent claims that they want to get rights over, these claims, they're called. And these claims have some distance to the prior art, some true distance to the prior art, and some private value. And those are exogenous on each of the claims that they have. And then they make the decision, do I want to apply for a patent or not? And if they don't, well, everything ends, so it's not interesting. We carry on and assume they do. The key choice that the applicant makes at the beginning with their patent attorneys in drafting is what we call padding. And padding is kind of exaggerating the true rights that you have. So you know the intellectual property rights that you truly deserve, but you want to gain as much as you can. And so you exaggerate a little bit what you have. And that kind of choice, endogenous choice in the model is called padding. And the applicant has to make this before they've sent it to the office, and I'll explain why that's important shortly. Once they've sent in their patent application, an examiner is assigned, and we follow much of the literature that says in many areas of technology these examiners are kind of as good as randomly assigned. And this examiner will search the literature, and you'll read the application that's been given to them and search the literature and assess the distance of the claims that's been sent in, the padded distance. But they will do this with error, and some examiners will correctly assess distance, whereas others will make error in their assessments of distance. So we have that in the model as well. And then we kind of enter this negotiation game where the applicant can grant patent rights, and then the process ends, and we move to renewals. Or more interestingly, if they reject the application, it goes back in the hands of the applicant. And the applicant can then decide, do I just abandon, do I give up, and then again we end the game, or do I fight? And fighting is going to involve paying legal fees and paying fees to the USPTO that vary by how many rounds of negotiation we are. And you're going to have to kind of shrink your claims a bit, narrow what you were trying to get. You concede a little bit and give in. And eventually this will keep on going. And this is kind of a really crucial point about the USPTO, which is the only way the examiner can end the process is by granting. They can't get out of it unless they grant. And so this is kind of a key point. We think in the US context, not necessarily the same in European context. And also just to add that we're thinking here of patents as a collection of multiple claims. So this is not like a homogeneous one-off object. It has several claims. That's how the examination process happens on multiple claims. So that's the bare bones. And so before, I'll go through some kind of key ingredients of the model, but let me just quickly mention what data we use. It's not novel to use patent claim text, of course, but we built one of these natural language processing models to get a measure of distance between patent texts. That's going to be a key ingredient in our structural model, the distance of the patent to the existing prior art. There'll be a presentation, I think, about these NLP stuff tomorrow, so I'm not going to talk about that at all. But this is something new we did at the time. It's exploding literature, as we know. We also have survey data from patent attorneys on the legal costs by tasks, such as drafting the application and fighting. We use a host of other sources of data, several things like renewal data. I didn't go through mentioning about the renewals model. We really have like a kind of standard Schankerman and Pecos renewals model at the end. We have the seniority of examiner roster over time and various other sources I won't go through. That's that. Okay, so I'm just going to talk through the ingredients of the model to give you a flavour, not the full details, of course, in this time. So a claim J has a true distance to the prior art. That's capital D star. And they know this. This is what they actually have. It's like, they're making a toaster with 2 slots, and that's what they know they have. That's what they should describe. And that's a certain distance to the prior art. And we use a beta distribution for this to match the machine learning output, which is between 0 and 1. Each of these claims also has a flow value, private value, to the inventor, which we assume, as lots of the literature did, to be log normal. As I mentioned before, the key endogenous choice for the applicant is padding. This is the extent to which you exaggerate your intellectual property. So, you have a toaster with 2 slots, but you say, I'm having a bread heating machine. That's a lot more vague. You're going to get a lot more, put out your boundaries a lot further. Or you could say I have bread preparation machine. That's very vague, very broad. You'll get very big rights, but we expect the examiner will reject you because you're too close to existing art. And that is the kind of key trade-off. So padding will increase your value. So the padded value of claims is V tilde, and that's multiplicative in padding. And so it increases your value, but it reduces your distance. If you're going to exaggerate, you're necessarily moving closer to the prior art, and you will get, you're more likely to get rejected. Padding also has a direct cost, of course, because you have to spend time with your patent attorney to draft this. One more crucial point on this slide is the fact, it's really important to note this, which is that the patent office, what are they thinking about here? They consider a claim invalid if the padded distance, which is what is given to the office, is below some threshold, is not far enough away. And what that means implicitly is that the office per se does not care about the true distance or the padding. The role of the patent office is not to remove padding. If they see something which is far enough away but has some padding, they still have to grant it. And this actually simplifies the analysis a lot for us. We don't have to have priors over these two objects, because this is how it works in reality. It very, very simplifies the model for us. So that's a very useful and important contextual point. A couple more points about the applicant. I'll go through these fast, none of them particularly interesting. Once we're in the negotiation stage, if an examiner rejects some of your claims, as I mentioned before, you have to narrow them, and this narrowing is some proportion eta. We can let that vary over rounds. In the current model, we use a constant amount over each round. And as I mentioned before, if the applicant is rejected, they're going to have to fight, and that involves fees to the PTO and legal fees as well. So we take seriously these legal costs that you have to pay to your patent attorney. They're typically quite large compared to the US PTO fees. Now, if your patent is granted, we have some constant depreciation rate of your values. This is typical in these models for renewals. We basically just add on a kind of renewals model after this process. And so we have obsolescence as well. Your value could just randomly go to zero if you're gazumped at some point. And this can happen during the process or afterwards as well. And the renewal decision happens, we model like in the US, where you renew at 4, 8, and 12 years. Okay, so more interestingly on to the examiner. The examiner is characterized by their seniority. So this is their general schedule GS grade in the government pay scale. And so their seniority is going to affect their payoffs, as I'll describe later. So it's an important part of the model. There's good descriptive evidence that senior examiners behave differently to juniors, so we wanted to take that seriously in the model. The key kind of ingredient of interest for the examiner is this intrinsic motivation parameter. Again, we assume log normal, it's not interesting, but this parameter, I'm going to explain how it plays a role in how we model intrinsic motivation formally in point 3. But before I get to that, I'll just say that, as I mentioned before, the examiner is given the patent application from the applicant, and they have to do some literature search. And they don't necessarily search the literature perfectly, and they might interpret distance with error. And this is some reflection of examiner quality, the extent to which they make those errors. So, how does intrinsic motivation play a role? Well, let's think about the payoff for an examiner for granting a patent. They get some credits, that's what G is here, for granting in round R. And this is like contributes to their extrinsic pay, and they kind of want to maximize their credits. They get bonuses for that. And that's a function of their seniority. Senior examiners are assumed to be more experienced. They can do this work quicker, so they get fewer effective credits for each decision. It also varies, interesting, by area of technology in the PTO. I guess they think that some areas are more complex than others, and so the credit should correspond to that. But that's the extrinsic part of the payoff from granting. So intrinsic motivation cost is theta times by R, and this is where the action happens. So what is R? R is the percent, or you can think the proportion of claims that they think are invalid. And so you have to imagine they're granting a patent here, and they know that some of the claims may be invalid in their opinion. And the key point is they make decisions based on their payoffs, right? What maximizes their payoffs? They don't just see something necessarily that has invalid claims and reject it. It might be in their interest to grant based on their payoffs, even though they know some part is invalid. So it's like knowingly granting even though some part is valid. So R is the proportion of claims that are invalid. So suppose in the extreme case this was 1, they're looking at an application, everything's invalid on it. So we should think that should lead to a large intrinsic motivation cost. If theta is large, then they get a big cost from granting something that's fully invalid. You can imagine they go home at night and they feel bad, they can't sleep because they granted something that was fully invalid. If R is 0, then they don't have any cost here. So that's how it works. Payoff from rejecting is again just credits plus a continuation value, because if they reject, the process is going to go on. So this is the way in which the model is dynamic. And I'll skip on the delay cost. We also have a productivity cost as well if they, for their time if they go multiple rounds. Okay, so good. So I've got about 5 minutes, just over 5 minutes left. That's the details of the model. Now comes the interesting part. I'll go through what we find, what are the estimates from the model, and describe some counterfactuals that we do as well. Okay, so the first finding is that the vast majority of claims enter the process with a distance below the threshold. So the vast majority of what enters the patent office is not valid. And padding, moreover, we estimate on average is 8%. But this varies a lot across applications, so it goes up to about 30% of padding for some inventors. And there are actually some inventors who negatively pad. This is, I guess, like a hedge because you really need these patent rights quick, so you don't want to go up against a nasty examiner, so you under-exaggerate a little bit, but it is positive on average and substantial. So most starts invalid, but only 1 in 5 granted patents contain an invalid claim. So this is the type 1 error. This is false grants. So you can see that, and this actually falls to 5%, when you weight by distance from the threshold. So what that means intuitively is that on these cases where they're granting invalid claims, it's marginal cases. This is not egregious errors that they're making typically when they grant invalid claims. So what these points mean together is that screening is actually effective given the standards that they have to use. So lots of what goes in is invalid, but nowhere near as much that goes out is invalid. And this type 1 error is much smaller than what I'm going to come on to type 2 error. So how does this all happen? It happens because there's a lot of narrowing. So each round, on average, they shave out about a quarter of what they're asking for. So that's how we get from the lots of entering invalid stuff with less leaving that's invalid. Senior examiners are less intrinsically motivated than juniors. This is an interesting finding. I guess there's some kind of jading going on over time. And finally, this is interesting, is the type 2 error is much larger proportion of type 2 error than the type 1. So 36% of abandonments contain at least one claim that was actually valid. And so that claim they should have been able to get in an ideal world. Okay, very good. So that's the model estimates. And that kind of highlights 2 of our key findings, which is that screening is actually relatively effective given the standards the office has to use. And I'll come back to that statement qualifier at the end. Now, so what do we want to do with this model is do some counterfactuals. So we have this table of results. So we have the percent of applicants who choose not to apply and the average padding that they do on those who do apply. The proportion that are granted in the first round, so this is the cases when the examiner sees it first time and grants immediately, and then we have the proportion of type 1 and type 2 errors. And we start with the baseline. I've gone through those results. The first thing we did was increase the round fee. So we said, what happens if applicants have to pay a big sum of money, or we thought it was a big sum, or we have to pay $50,000 per round to try and make this process move a little bit swifter. And that actually had limited effect on type 1 and type 2 errors. So these inventions are typically very valuable. So rounds fees did not work, is not so potent. But what is potent is rounds restrictions. So as I told you, currently the process could go on ad infinitum. Well, we put a restriction now on the model where we say it can only go 2 rounds now. And we see there's a huge increase in the amount who choose then not to apply, and padding basically vanishes on average. And so applicants, knowing that they only have potentially 2 rounds of negotiation, suddenly go, with that in mind, they endogenously don't pad so much. And type 1 error therefore shrinks, but as a result, type 2 error rises because there's a lot more valid stuff in abandonments when there's only 2 rounds. It's more extreme with 1 round. One more point is that we thought of doing, well, what happens if we kind of remove most of intrinsic motivation? And that's catastrophic for type 1 error. When these examiners don't have any intrinsic motivation, 90% of granted patents contain at least one invalid claim. So you can see how we argue that the intrinsic motivation is very important to hold up the current patent office process. So what you can see across these counterfactuals is there's generally a trade-off between the amount of type 1 error and the amount of type 2 error. When you make the process harsher for the applicant, in some respects you say you can just have 1 round, type 1 error is going to shrink. They don't try and ask for as much. There's fewer type 1 errors, but type 2 error rises. There's a trade-off. What we want to do in the final part of the paper is to put some social costs on these errors. So the social cost of granting invalid patents is the fact you're giving temporary monopoly rights to someone who doesn't actually deserve it on these claims. And also it can lead to costly litigation. So these go into the cost of invalid grants. Now the ex post cost of valid abandonments, when someone has patent rights and they don't get them, is ex post cost is nothing because they've given us the patent document, we get that for society, and we don't have to give these temporary monopoly rights. So ex post, there's no cost, but ex ante, it dilutes the incentives. These people, knowing that there could be type 2 errors, won't apply or won't develop in the first place, and that's costly. So we calibrate a kind of extension of the model to calculate these. Now, what do we find? On net, it's $26 billion per cohort of applications, the sum of all of these social costs, so type 1 costs, type 2 costs, and the cost of running the office. Now, when we do round restrictions, this goes down. That's the finding I'll highlight here. So if we go to the most extreme case where you have 1 round of negotiation, then you get half the social costs. And intrinsic motivation, if you get rid of most of that, it's almost doubling the social costs. So you can see the importance of it. This is good. I've got a few more seconds. I want to conclude to give the takeaways. So we've developed and estimated a structural model of patent screening. That's what we did in this paper. Our 4 key findings are as follows. First, much to our kind of surprise, patent screening is relatively effective given the judicial standards of patentability. So we're not making a comment on this paper of whether the courts are giving them the right threshold. That is a separate question. But given the standards the courts give to them, they implement that quite well. The effectiveness is driven by a high degree of intrinsic motivation amongst examiners. You take that away, things go vastly the wrong way for us. Total social costs are around about $26 billion per cohort, and the key counterfactual that seems to have some bite is restricting the number of negotiation rounds. And we really hope that there can be further applications to other kinds of innovation promoting activities in the future. So thank you very much.
Thank you very much.
Great. Thanks so much. Thanks to Will for a wonderful presentation, very clear, and wonderfully complimentary. I made the right bets on what to emphasize. Now, let me start by one observation, okay? Mark has developed structural models for a long time, and this is following in a tradition, but this is now a level of sophistication that we haven't seen before. And I felt reminded, one of the students with which you did that was Jenny Langeau. And when Jenny presented her paper at NBER, Ariel was there. And Ariel said, I didn't think one could make these models more comprehensive than that. And here I stand and tell you, I didn't think one could make these models more comprehensive. This is a wonderful exercise, and I think
so
it
you're
really
done with your
gets
discussion.
us. Sorry?
You're done with your discussion?
No, not. I have minor quibbles. I'm a discussant, right? Okay. So, structural model of patent application, but really into the nitty-gritty details of organization, something that we haven't had before, right? Incentives, intrinsic motivation, negotiation rounds, multi-round negotiations, and so forth, stuff that we have been talking about that could be important, but they now embed that in the model, okay? Institutional data of a richness that, I don't know, I think you have 11 or 12 data sets that you combine here in order to bring this together. Of course, a little bit of NLP, semantics, and so forth as well. Counterfactual analysis of some patent office reforms. This is complementary. Please read the other paper, which is also great. But I think this can do even more. It also does other things. So I've praised you already. Extremely detailed modeling, combination of rich data, and including intrinsic motivation. This takes us into behavioral territory. And that's good, because we know somewhere in the back of mind that this is important, but we haven't been able to put it in there. Okay? And the counterfactuals are also very interesting. So I took from the paper the slightly more elaborate picture to point out to you. Will had this horizontally, and it gives you the various phases that are modeled here. And the really novel elements, there's of course the intrinsic motivation, which is hidden away in the psychological cost, in the cost function for the examiner. That's not in here. But just in the course of steps here, the padding, also, I think, very realistic. We have been talking about this for a long while, that applicants come to the office with patent applications that overstate their case, right? They are padded. And then, of course, the multi-round negotiations, which are very pronounced at the USPTO because the examiner does not have the right to finally say, as the colleague at the EPO can do, this is it, I reject, go home. Okay? Take your course up with the appeal boards or whatever else. So I think a great deal of realism that comes in here, while at the same time maintaining tractability. Okay, let's talk about padding, because there will be a little bit of a quibble and a suggestion. So padding is the notion that around this claim or patent J, I pack a lot of stuff, okay? I claim broader scope than I want to have. And that gives me benefit in some way or form. And that changes my distance to other claims and inventions. And they have nice measurement for that, because the claims are processed, vectorized, and then we can do the normal vector operations, generate distances, and so forth. So the trade-off here is for the applicant between entering another round of negotiations, because if the examiner rejects, then they have to say, I request continuation of examination, RCE. You need to introduce the acronym somewhere. You have the acronym and the term in the paper, but they never pop up in one place. And broader scope of the patent, which I want, okay? So the focus on the claim wording then means to keep rivals away. I've created a graph that says padding 2.0 because there's another padding technology out there, which is simply that I don't work too much on the claims in that one focal middle J. I put others around it. Other patents, continuations, divisionals, continuations in part, okay, which happens a lot at the US Patent Office. And just in order to show you that it happens a lot, I picked this example. Okay, you see here, this is from Google Patents, that's an application, and so forth. It has one WIPO, WO, one EP, one Israeli, and then tons and tons and tons and tons of very, very, very similar US patent applications. So you might think that this is one out of Dietmar's horror cabinet of strange patents. I have a horror cabinet of strange patents. It isn't. This one was a new one to me, okay? So, but what you find is you find these large patent families within the USPTO. So this is not the patent family notion that Jonathan, one of Ariel's students, Jonathan Putnam, put up, the international patent family. This is the within USPTO patent family, okay? Stuff clusters, and applicants make it so. And what you find is that they are derived from one or very few priorities. They have the same or similar application dates. They have the same or similar titles, figures, tables, claims, and what have you. Okay? Is this the freak show? Is this a singular one? Here are my data. No, it's fairly frequent. 25 to 30% of patents are embedded in these structures. Okay? So how can I say that? There you have, for 3 filing years, I gave you the application numbers at the USPTO, utility patents only, no plant or design or other stuff. And then there are 2 definitions of patent families. These are hard definitions. You can link these patents by priorities. This is not semantics. This is not large language or anything, right? This is a hard link in the data. And you see that from 355,000 in 2005, the number drops to really independent patent families to 285,000. That's considerable. That's 20%. If you go to other years, you find even greater ones, okay? Other patent offices are very restrictive on this. If you go north from the US to Canada, they don't allow that at all. If you go to the EPO, you find a decrement of maybe 5%, okay, between patent families, 5 to 10%, depending on technology, between the applications and the patent families. So, could it be that the patent families are really the logical units that we should think about, that the inventors and the owners really want to have some protection for a given invention, and be it by having 3 patents surrounding the core of that. Okay, that's the idea here. So, implications. What does it do to the claim similarity measures? Probably nothing, because they have the same dates, so they're not prior art, harmless. Okay. Nonetheless, I would want you to check. You have these lists of 50 very similar claims, right, that come out of the semantics. By the way, wonderfully done. How many of these point to patents of the applicant? Because that might be important. Because the battle that you show or that you talk about here is between the examiner and the patent holder. Now, the examiner has incentives to go fully in and delineate patents no matter who owns them. But the applicant has very, very clear incentives to build something out of several patents, so they might not fight back against the examiner under certain circumstances. So you have changes in the behavior, okay? So that might also, for example, affect interim round abandonment, because if I see that one of my applications is going well, I may drop the other one. So this might not necessarily be immediately related to technological obsolescence. What to do about it? So a radical change would, of course, be to have another model. Let's not do that. Let's be constructive. The pragmatic one would be run this, choose one random element out of families, show that the results don't change, robustness change. And a more convincing one would be to combine the patents in families of one pseudo-patent. You can do that. NLP can do that. Because you're working over multiple claims in any case. So now you have maybe 12 claims that you're working over rather than 2 or 3. Okay, I'm out of time already.
Yeah.
I'm all. The wonderful estimation, I said already, I think, Mark, you were in Munich in 2012. One of my doctoral student presented a paper, and he wanted to go from 7 parameters to be estimated to 8. And he said, you might get lost in the way. So this is progress. We're now at 15, okay? And that, of course, entails the possibility of doing something really complex, like organizational stuff. Okay. The counterfactual analysis is really, really fascinating. Let me focus on one point. You say, we conclude from our data that the extrinsic incentives, okay, so that's essentially the cost function of the payments and so forth, the point logic that the examiner is under, right? And the psychological, the disutility from being wrong, right? They act as substitutes. You say, we contradict the experimental literature. You may lose that fight because the experimentalists have looked very carefully at how they put motives and so forth in, and they observe them directly, okay? So maybe tone that down. I think it's an interesting result, but reading the experiments, I still would think that the complementarity result coming so convincingly out of the experiments might be the better one. I'll send you the suggestions. I don't want to steal time. There are, for example, on the padding, the examiners broaden the first independent claim. They make it longer to make it less specific, more specific, right? So that's an observation possibly on padding that was there before. Maybe you can compare the distributions to your padding estimate and so forth and do something about that. Okay. Of course, technology-specific estimations, you say that in the paper, and comparisons to other organizations like the EPO and so forth. Wonderful paper, kudos, right?
No,
you really have
Thank you.
taken us further. Wonderful methods and data. Thank you.
Thank you. So I give you a few minutes to respond to this.
I only have a couple of things to say.
Particularly
Thank you so much for the comments. When you were saying about this other padding story, I was seeing there a little bit of trepidation because I was imagining, could we take this one step further and build a model of multiple families? But as you said, there's no need to do that. This is a structural model. We're not it's not, we just simulate the model. So it's about changing the moments and looking in the data about combining families perhaps and recalibrating the moments as a robustness check. And I think that's a really good idea. So that's what I'd say on that. And comparisons, of course, I mean, we were speaking this morning. We were under the impression there's just no data from the EPO or other ones. Maybe there is. I mean, we'd love to. But I guess you're saying just mention them, but we would love to do this in other patent offices. And so that's all I'll say in response.
Oh, that's very efficient. Yeah. So we have questions?
Yeah, so I already have mics. So.